Hello, and welcome back to XRP Vault, where we bring you the most recent and intriguing XRP news. We're giving away 10,000 XRP to those who are watching. All you have to do is upvote, subscribe, comment XRP is king and watch the video to the end to be eligible. The winners will be picked next month and publicized on the community page of the channel. For the SEC, the past 24 hours have not been easy. We actually achieved a significant victory in the Ripple SEC lawsuit last night. And I had the chance to discuss it on Twitter with both Jeremy Hogan and his lawyer, Fred. In this video, I'll go over everything I've discovered and what it means for the future of this case. I want to explain exactly what will go to trial, what will be resolved at summary judgment, and how close we are to a decision because it appears that, notwithstanding ripples, the likelihood that this case will go to trial is rising. You guys don't want to miss this since there is so much to cover. Two more significant cases are ongoing at the moment as well. The SEC recently lost one of them, and it appears that they will also lose the other. We'll dissect those as well. So let's hope I don't run out of time and we finish the entire conversation. Thus, let's begin this video with a case that the SEC recently lost. Also, I spoke about this yesterday evening on the channel. I didn't anticipate that we would already have a decision in this case, but it was announced immediately before I recorded this video. Hence, we will discuss it. Just in time, the judge dismissed the SEC's objections and permitted Voyager to sell assets in order to purchase Nance for $1.3 billion. In essence, Nance was attempting to purchase the assets of the Voyagers from them. To sum it up quickly, no one who had paid Voyager was going to get their money back because, in essence, it was an exchange that had filed for bankruptcy. The only way for these clients to get their money back would be for Binance to purchase Voyager and restore liquidity to the exchange. This would only be possible because Binance has the funds to do so. In essence, this would then be the best way for Voyager consumers to get their money back. Now, in an odd move, the SEC intervened and attempted to prevent Binance from purchasing Voyager, despite the fact that doing so would have been best for Voyager's customers. In an attempt to label it a securities transaction, the SEC and some of the assets aboard Voyager were security-related, so Nance couldn't board Voyager. The judge, however, was not amused. How could you expect anyone to know what you're thinking when you refuse to give any clarity to this asset class? You're coming in and saying that these parties are breaking the law, but you haven't made any clear statements on what laws they're breaking, as the judge basically said in the court hearing the other day. Hence, it appears that the judge entirely dismissed the SEC's attempt to halt this sale just today. Given by Nance to win, and Nance will be allowed to purchase the assets of the Voyagers. In my opinion, this shows that there is no certainty in this industry, as well as being a significant victory for Voyager's clients. SEC Chair Gary Gensler is continually emphasizing that the regulations are clear. The regulations aren't clear, and you can't run about abusing your authority. The courts are now explicitly warning his agency. When the guidelines are unclear. This is a slap in Gary Gensler's and the SEC's face. That demonstrates that their theory, that cryptocurrencies only pertain to the previous securities regime, doesn't hold up under judicial scrutiny. Also, it's a positive move in the right direction, and demonstrating that the SEC's claims aren't all that strong if it faces opposition to what it's doing and can't simply intimidate corporations into settling. And many of the explanations they give the public have been proven true in court. Before we discuss the rippling SEC lawsuit, let's talk about another action the SEC took today, becoming Grayscale. Now, this case has not been resolved. Actually, it was only the initial hearing. For those of you who don't know, and I'll quickly summarize this again, basically, Grayscale is trying to get their GBTC product and ETF on the market. They want it to be the first spot ETF on the market, but the SEC is denying their approval and only allowing futures ETFs on the market. Let me tell you, this was absolutely embarrassing for the SEC. This is absurd because Bitcoin's price, which is the basis for both spot and futures ETFs, is the same for both. One of them is being approved for the market by the SEC. It is suing the SEC, not the other two Grayscale agencies, claiming that this is completely ludicrous. As with other cryptocurrency disputes, it is crucial to find a judge who is open to hearing from the cryptocurrency corporation. Because they don't feel like studying about cryptocurrency, many judges in the United States simply rubber stamp anything a regulator says. They will just state, "Well, the regulator is probably right here." As a result, the judges in the Grayscale case, however, were not at all amused by anything the SEC claimed, and they pressed the SEC attorney with the following question: what distinguishes a futures ETF from a spot ETF? They both have the same foundation, right? How is it possible to claim that one piece of data was changed while the other wasn't? The SEC attorney continued returning to the judges and stating, well, it's kind of a chicken and the egg thing. If they are both dependent on the price of Bitcoins, whether spot ETFs or futures are being manipulated in reality is unknown. Therefore, we can't authorize the spot ETF. But the judge deemed that to be completely ludicrous. You just stated that you are unsure of which is being manipulated, despite having already approved the futures ETF. What makes authorizing the spot ETF different then? And throughout the duration of the trial, the judges seemed to think the SEC's entire argument was utterly ludicrous as they grilled the SEC's attorneys since they couldn't seem to comprehend it. There will now be additional hearings in this matter. Yet, based on everything I've observed from this initial hearing, John D. and I both felt that the SEC is in trouble in this situation. These judges are unaware of what the SEC is up to. It makes no sense to them. And the reason for it is that they performed the study, examined it, and realized it made no sense. It has nothing to do with any merits, and the SEC is refusing this product to prevent cryptocurrency from growing. In the end, this is a fantastic move, and losing this lawsuit would be devastating for the SEC. And based on what I heard from the judges today, I believe it's just a matter of time before they lose this case. For the first time ever, it appears that I am actually moving along fairly quickly. Let's try to quickly go over what we learned about the Ripple SEC case last night. We have a very bullish development that is significant for Ripple's chances of winning this case. And we also have something to discuss that most people won't like. Keep it until the conclusion. Let's start off by discussing Ripple's major victory. Last night, Judge Torres was given the authority to decide which experts would be allowed to testify in this case, and which ones she would exclude. Both Ripple and the SEC brought a large number of experts to testify about particular issues they believed were crucial. Judge Torres also had the authority to decide which experts would be permitted to speak and which ones would basically be dismissed from the proceedings. The SEC expert who is testifying about what XRP holders believed when they purchased XRP was actually ejected by Judge Torres, which is the most important development in this ruling. The SEC expert that Judge Horst threw out of this case was supposed to be making that precise point for the SEC, and that is why this is such a big matter. One of the requirements of the Howey test is that an investor must expect a positive return on the item they are investing in. He was going to argue that when XRP holders purchased XRP, they were merely attempting to invest in Ripple, and thus the court should dismiss this individual's case. And to make matters worse for the SEC, she actually allowed John D., one of the 75,000 XRP holders, as well as all the businesses that submitted affidavits, to speak on behalf of the fact that, hey, a bunch of people use the XRP ledger who aren't even related to Ripple, and people need to buy XRP to use the ledger. Nothing about this relates to investing. It's just pure functionality, nothing more. This is a major problem for the SEC since it essentially kneecaps their defense of being rated poor against one of the Howey test's primary criteria. The SEC just lost their expert at a crucial and essential stage in this case, and since they don't now have someone lined up to discuss this matter, they will now find it very difficult to prove this prong of the Howey test. And Ripple is showing tremendous strength by demonstrating that thousands of people and thousands of businesses are using XRP to avoid investing in it. The SEC suffered a significant loss as a result. And nearly every lawyer I've seen who commented on Judge Torres' judgment agreed it was fair and well balanced. Yet when it comes to demonstrating that XRP is not a security, Ripple came out on top, and the SEC definitely got the short end of the stick. The fact that the majority of the attorneys monitoring this case now believe there is an enhanced likelihood that the case will proceed to trial is news that many people will not appreciate. We have a lot to talk about in this case. First off, the majority of the attorneys don't believe the whole case will go to trial. I have to say that Attorney Fred's explanation of it actually made sense to me, and I firmly concur with him. He believes that the Ripple case, which concerns how they sold XRP, may go to trial, and he believes that has the greatest chance of happening. Yet, Attorney Fred believes that Judge Torres won't want the entire matter to go to trial. Imagine how much of a show it would be if John Deaton, 75,000 XRP holders, and all these companies that filed affidavits were forced to go to trial. It would be a massive mess. Judge Torres is going to want to cut the case down before it goes to trial. Attorney Fred really believes that Judge Torres will order the SEC to acknowledge that their case has nothing to do with secondary sales going forward. As a result, the SEC would be unable to establish that XRP secondary market sales constitute securities and would effectively remove XRP holders from the lawsuit. This is a huge victory, and this would enable the relisting of XRP on exchanges, the continued use of XRP by people like you and me, as well as the development of any single project on the XRP ledger. Whether or not their ODSO product is compliant, Ripple would still have to fight the SEC over how they sell XRP in the future. Yet none of that is particularly significant, and the SEC and Ripple can negotiate a fine to settle the matter once and for all. Now, all of their attorneys, including Jeremy Hogan, still believe that Judge Torres will make all of the decisions and that summary judgment will still be granted. There is some disagreement then. Yet, based on my observation, the majority of the attorneys believe that at least some of the cases will proceed to trial. We are unsure of the specifics of what may transpire. Yet, the good news is that our wait won't be too long. Nearly every attorney who is keeping track of this matter believes that summary judgment is imminent. That should take no longer than 2 weeks, at the most. Nonetheless, practically all attorneys believe that summary judgment is imminent. And up until that time, all we can do is guess what will be tried and what Judge Torres will rule on. The last thing I should mention is that practically every single attorney I've spoken to is very sure that if this case goes to trial, our prospects of reaching a settlement actually increase. No party wants this matter to go to trial, say all the attorneys. Even for the SEC, it's a massive waste of time and money because it will keep them very busy and divert them from the other cases they are working on. So, that may significantly increase the likelihood of a settlement. Like usual, a settlement can be reached before summary judgment. Yet, I believe that is currently far less likely. At this moment, all that is left to be done is wait for Judge Torres' decision, which will likely come in the next several days. The good news in all of this is that the majority of attorneys concur that there is currently very little chance remaining for XRP to be classified as a security. The majority of this now just depends on what occurs and how much of a fine or smack on the wrist will be issued. However, when it comes to XRP holders being involved in this lawsuit, most attorneys concur that the SEC has the upper hand and that losing their most recent expert killed their chances of establishing that XRP was a security. Thus, it doesn't matter what happens at summary judgment. I think we should all simply be glad that XRP won't ever be classified as a security. Nevertheless, I really appreciate your being here. I hope this update was enjoyable. Please be sure to like and subscribe if you did. For the time being, it truly means a lot. Nicolau.